I Hate Politics is a podcast about a human activity we love to hate. I'm Sunil Dasgupta. We often talk about how one major sickness or a job loss can dramatically transform the fortunes of a family. Here is an episode that tells you that it could just as well be a brush with the law. An arrest is an ordeal in the best of circumstances. But did you know it could also ruin your family finances? Lawyers are expensive enough, but if you are judged not to be indigent, you might have to pay for your own pretrial supervision. And if you have been falsely accused or otherwise acquitted, there is no remedy. Bail reform in Maryland was supposed to bring down the number of pretrial detainees, but it shifted the numbers, allowing pretrial release for lesser offenses and increased detention for those charged with more serious crimes. Not Maryland, but in some states, you have to pay for your own incarceration. We know the criminal justice system is broken, and even knowing that, this episode has been an education. My guest is Natasha Darteague, Maryland's public defender and the new president-elect of the Maryland Bar Association, which means she becomes president next year in 2026. Stay with us.
I Hate Politics is brought to you by UMBC's Political Science Program, where you'll learn to shape public policy, impact communities, and function at the center of modern society. Learn more at shadygrove.umbc.edu.
I got all the rest of my life to figure out what I didn't get right. I got all the rest of my days to figure out how I let you slip away. Take me back to the nights that
I Hate Politics is a podcast about our neighborhoods, workplaces, schools and streets, and our local governments as they function in diverse and democratic societies. This means our politics are messy, dirty, sometimes corrupt, with often self-serving politicians. But no matter how much we may hate politics, we are never exempt from it, even when we refuse to participate. In fact, the purpose of politics is to keep society functioning, precisely when we don't agree with each other, like now. We celebrate new music for the summer, and this is Silver Spring's own power pop band, the Airport 77s. Andy Sullivan on guitar, John Kelly on drums, and Cal Everett, famously of the band 4 out of 5 Doctors, on the bass. The songs we play come from their brand new album, Don't Let Go. You can find the Airport 77s at airport77s.com and at live concerts all over the DC region.
pop radio, baby, one more time. Take me back before it all fell apart, before you broke my heart. Take me back to 1999. We thought it would last forever. The 31st of December, singing along with the pop parties over Woodside of time.
Natasha Darteague, welcome to I Hate Politics.
Thank you for having me.
What do you see as the shortcomings of Maryland's pretrial monitoring system?
We oppose pretrial confinement and we oppose pretrial monitoring as it in fact disproportionately impacts Black people and continues to contribute to ongoing inequities within the criminal legal system. These type of restrictions leads to often loss of employment, housing instability, family disruption, and exacerbates whatever current economic or social condition that the person lives in. We also know that these type of pretrial conditions don't necessarily increase the likelihood of the person appearing in court. So the things that are actually successful in a person appearing in court are like the everyday things, like sending a text reminder, having some sort of alert that reminds you of the date. Those are the kind of things that actually determine whether or not someone is going to appear in court. And that is really the main purpose, is to ensure that the person is going to appear for their court hearing, because we still exist in a system where a person is presumed innocent until, in fact, proven guilty.
It seems that there is a preference in the system to punish before trial.
That is, in fact, a fair statement in many instances. When you see how the system moves and how individuals are treated from the point of arrest to the final disposition, we create circumstances where before a person is even found guilty, that we are negatively impacting them and their lives.
Why should that persist despite the efforts of people like yourself and others who have fought against it?
There is the underlying racial biases that exist, and especially we talk about in Maryland. And racial profiling is real, disparities in policing is real. The result is that then you have a large number, in particular Black people, Black men, who are entering the criminal legal system at higher rates than other Marylanders. In fact, Black people are nearly twice as likely to be arrested than white people. So as you have this domino effect that then is then compounded by what was initially started through by racial bias, you see it then when the individual is arrested. You see it then in determination as who is released on bail, who is given home detention, who is not given home detention.
My expectation was that punishing before you're found guilty would happen at a lower rate in the courts than in policing.
So there was a 2023 study that indicated that the probability of a detention recommendation was 34% higher for a Black person than for a white person. And this is especially when we talk about the least serious crimes. And data shows us that about 43% of Black people were held without bail compared to 31% of white people.
What period?
So I believe this comes from a 2023 study. I don't have exact site in front of me, but I would tell you as a resource is essentially the release of the report by the Maryland Equitable Justice Collaborative. Maryland Equitable Justice Collaborative is a collaboration between the Office of the Public Defender and the Office of the Attorney General.
In response to these numbers, Maryland tried to do bail reform. What was the impact?
The move was to get away from cash bail. So cash bail is essentially you are arrested and a dollar amount would be determined that you would have to post before being released. So if you were somebody of little or no means, that was tantamount to no bail. So Maryland did away with cash bail. But what ended up happening is that for the lower offenses where there should have been no cash bail to begin with, it was removed. But then when you had other offenses that wanted to be maybe perhaps more serious, then the move was less likelihood that bail would be given in those instances. So instead of having a decline across the board in terms of the number of individuals held, it was more so a shift. The change, what we saw, was more so in the type of offense being held, not necessarily a decrease overall.
Bail reform was introduced in 2017 in the expectation that pretrial detention would be reduced as a consequence, and you have not seen that reduction. We say low-level crimes and high-level crimes. Can you just give us examples so we can distinguish that?
Let's say a theft of a cell phone. That's for something less than $1,000.
Okay.
Or a dispute among neighbors that resulted in malicious destruction of property.
And what would be a high-level crime for which there was now no bail?
A burglary or a robbery, whereas simply because of the charge, then the individual is given no bail, but the circumstances may be that, in fact, there was nothing taken, or there was nothing of value taken, or there was no force used. But yet, simply because of the charge and the circumstances of the case, or if a person had prior contact with the criminal legal system, then they would be looked upon more harshly, and then a no bail situation.
Maryland has 24 jurisdictions. They have different processes and resources and how they manage pretrial detention and release. Can you speak to what those differences are and what the consequences of those differences are?
Jurisdictions vary in terms of their pretrial systems. For example, Baltimore City pretrial falls under the Department of Corrections, whereas the other 23 jurisdictions, pretrial is run by the individual jurisdiction. So that in and of itself is going to create a difference because the Department of Corrections is a state entity versus the local jurisdictions. It's a funding difference. It's also in terms of who uses private detention versus who doesn't use any detention. So like, for example, Baltimore City will use private detention, but it is state funded. So if you are put on pretrial detention and it is determined that it will be through the state contracts with private entities to pay for the home detention. So that means that when you have circumstances where the state has severe funding issues, that then impacts, for example, Baltimore City, and it has an impact in terms of the home detention program. Baltimore County uses private home detention as well as county home detention. Coward County is more so just pretrial supervision. They don't really significantly use home detention. Dorchester County, and it's a county program that is just exclusively through their local jail. Frederick uses local as well as private. Washington County is a private pretrial. Wicomico County is through the local jail.
What is the consequence of these differences?
That goes to the question about cost. So for home detention, it averages around $14 a day. And this is outside of the servicing fees, the setup fees. So let's say in a given month, you are paying easily over $400 a month. We saw this really exacerbated during COVID. So you think about during COVID, the length of time in which somebody was on pretrial detention was severely extended because there was that significant period of time when the courts were not operating at 100%. So if you were on pretrial detention, that just kept it longer. And if it was private and you were paying out of pocket, that is essentially a longer period of time that you were paying out of pocket. We did see some relief, especially during COVID, where, for example, like Baltimore County had waived the fees for a certain period of time to help that load that was now placed on families.
How many pretrial suspects are in private hands and paying for it, and how many are not paying for it and that's being paid for by the local government or the state government or whoever?
The only one I know offhand is Baltimore County. So Baltimore County uses a hybrid of private and county home detention, and about 75% is county program and 25% is private.
How do they determine who to send private and who to send public?
For clients of the Office of the Public Defender who are deemed indigent, if it is in fact available, then they are generally placed in the county programs. But there are individuals who family members take on the responsibility of payment.
So we are actually charging suspects for being a suspect. What happens if they are acquitted? Do they get paid back?
That is a great question because, and this is where the whole issue of pretrial and pretrial detention and bail kind of really battled head on, because no, you don't get that money back.
You're taking my money.
Yeah.
You didn't find me guilty. So why are you taking my money? If it's dismissed, then there is no case against me. So why am I paying for pretrial detention?
Because that was a service provided to you pre-trial. That is essentially so that you are permitted to go home. A independent company has said, okay, I will monitor this person while they are home, but this is a service and you're paying for that monitoring service.
How long are suspects held pre-trial? Is the number of days going up or down?
It varies by jurisdiction depending upon the number of cases in a particular jurisdiction. So jurisdictions such as Baltimore County, Baltimore City, Montgomery County, Prince George's County, where you have a high number of arrests, consequently you have a high number of individuals charged, there is a high number of cases that are coming before the court.
But I imagine they also have higher number of judges and higher number of police officers, larger budgets.
There's still a finite number. For the individuals who actually want to resolve their cases by trial, that tends to go up and is proportional to the number of cases that currently exist, because priority is generally given to an older case. If you are seeking to resolve, if the case is not dismissed, and you seek to resolve your case by way of a guilty plea, then there's a greater likelihood on that date that you come in that it will be resolved. But if you are actually looking to have a trial, then that is what adds additional time.
So, but that's a perverse incentive. It is basically telling me as a suspect that I should plea out of this if I want to save money, even if I believe that I am not guilty, even if I have not done something. If you are going to impose such a cost on me that then I cannot meet that cost, or I impose undue burdens on my family, then what is the chance that I would go, okay, fine, I'll take the plea?
And that is in and of itself one of the things that is broken in the criminal legal system.
So it is clearly not broken now or even in 2017, but has been broken for a long time.
Yes, and many will say that in fact the system works as it was intended to work, because then it serves to continue a cycle of incarceration, the breakdown of communities and individuals.
But how is that not a breakdown? I mean, this system, this incentive system of pleading out even when perhaps you may or may not be guilty, if that is a system and you achieve that purpose by imposing costs on pretrial suspects, then how is it the case that this is even working and this persists for such a long time?
It is just an indication of our society as a whole.
When you blame everybody and everything, then we're not being able to identify where the problem is and how to affect change.
That's not what I'm saying. I'm saying where you start to change the system is to end the over-policing of Black and brown people.
Prevention is always better than cure. But even within the cure, those now in the system have a perverse incentive to take the plea. Otherwise, they're going to end up paying a ton of money in their own pretrial monitoring, and it could go on for a long time, and then they're not reimbursed for it afterwards if they're acquitted, or the case is dismissed. If there's a false allegation, for example, is there no remedy?
No, there is no remedy. And this is why I stated at the beginning that ideally would be a system where there is no payment for individuals pre-trial.
Do you think a standardized, uniform, statewide pretrial system is what is needed at this moment in order to overcome these shortcomings?
So one of the issues that we sought to address with the Maryland Equitable Justice Collaborative, because our mission is in fact centered on addressing systemic inequalities, particularly the over incarceration of Black people, we put forth certain recommendations that would directly address unnecessary pretrial detention. So, and it has three parts. In looking to reduce the unnecessary pretrial confinement, it would require, for example, a change in the district court discovery rules. And that would help in terms of reducing pretrial population. And those are the populations where we know that Black people are overrepresented.
What is that rule change you want in discovery?
So essentially, currently in the district court, the state is not required to provide discovery before trial. So it would give the state a specific deadline in which they are required to provide discovery. So right now the rule is reasonable time. And unfortunately, that is very subjective. So we have situations where the state is providing discovery, which is essentially the evidence that they have against the individual, either on the eve of trial or the morning of trial. So if I'm the attorney, defense attorney, be it private or public defender, receiving evidence the night before, the morning of, that is naturally going to create a postponement situation. So if we have specific rules that require the state to give discovery to defense, let's say 10 days before the trial date, then we're going to alleviate some of those last minute discovery postponement requests.
You said that you need new discovery rules in the district court. Are there already discovery rules in the circuit court?
There are different rules in the district court and the circuit court. And the distinction in the district court are generally your low-level offenses, your misdemeanors. And for the majority of the everyday person, the contact with the court system is in the district court. The circuit court are the more serious felony offenses. Currently, there are rules that apply to discovery in the circuit court. So essentially, there are rules that require the state to provide the evidence that they have against the individual no less than 30 days before the trial date. That is the rule that exists in the circuit court, and it does not necessarily require a demand by the defense counsel. In the district court, there is no rule that has a timetable in which the state is required to provide discovery. And in the district court, there is the responsibility of defense counsel to make a affirmative request. So what you end up happening, especially when in the district court, things are moving faster. Generally, your first trial date will be within 30 days. So you have counsel entering their appearance, and then the trial date comes quickly. And very often it's only a couple of days. Sometimes it's the day before. Sometimes it's the morning of. You are receiving critical pieces of evidence. For example, you are receiving a body cam video the night before or the day before. And that creates a situation where, as defense, you have not had an opportunity to review that body cam, a critical piece of information, then you are then asking for a postponement to review evidence. If there is a rule change that requires the state, especially in the district court, to provide discovery, to provide the evidence against the individual, at least, let's say, 10 days before, it would reduce some of those automatic postponement requests.
Do you think it will also push the case dates back?
It should not, because essentially the evidence that the state is providing is what is in the hands of the police, which exists at the point of the arrest. And especially now, information is transferred electronically. Things are instantaneously transferred.
You said you had two other recommendations. What are they?
One of the other recommendations involve developing a civilian complaint review process that is uniform across all the state's attorney's offices. And the other is allowing the individual to waive their right to a bail review hearing. And when we talk about having a uniform civilian complaint review process, that is essentially to make sure that regardless of where I am arrested, that certain mechanisms are in place to make sure that, in fact, the process is treating everyone fairly.
What does it mean for an individual to waive bail review hearing?
When you are first arrested, you are brought before a court commissioner. And essentially, the court commissioner will, in fact, make that preliminary determination of bail. There are instances where the commissioner has made an assessment and determined that the person should be released on their own recognizance. If the person is not immediately released, then under the law, no later than 72 hours from arrest, they should be brought before a judge. There are instances where the individual is attempting to secure whatever the circumstances have been determined by the commissioner for their release, but then they're brought before a judge. And the judge then has the opportunity to review, change, or modify in any way what the commissioner had predetermined. So there are instances where the individual, like I said, is working to be released, and then the judge comes and imposes a different.
What have been the barriers to achieving these goals?
The district court is a rule change, and there is a process, a judicial process that must take place to introduce, then to ratify rule changes.
Where does that happen? At what level does that happen?
So that happens at the level of the Supreme Court of Maryland. And there is actually a rules committee that reviews proposed changes. These are recommendations that were reported by the Maryland Equitable Justice Collaborative, the MEJC, and that was done in March of this year. We are now in various phases, and we are beginning the implementation. When we speak about a civilian complaint review board, those are local legislatures.
Change has been really hard, as we talked about earlier. All the perverse incentives in the system and the discrimination and biases in the system have persisted for decades. Are you hopeful that you'll be able to make these changes?
I'm incredibly hopeful because the MEJC, Maryland Equitable Justice Collaborative, is different in that it is a collaboration between the Office of the Attorney General and the Office of the Public Defender, a partnership, number one, that has never existed in this way before. And part of the collaborative is that we brought in members of the community, and that included members of the General Assembly, various agencies, Department of Corrections, Department of Labor, Department of Juvenile Services. We also brought in individuals who are doing the work every day on the ground, individuals from the various programs and industries within the community, as well as we brought in our academic partners, University of Maryland, Bowie State University, into the conversation. So it is a collaboration of all the different persons who are essential parts of the solution coming together. And for this reason, I say that this initiative is different, and the work that has been thus far by the collaborative is transformational. And we hope to move forward in that same energy to, in fact, ensure that our recommendations are, in fact, put into place.
Natasha Dartig, thank you for taking the time.
Thank you. This has been fun.
'Cause I'm in, if it's on, I'm in, can't wait to...
What lessons can we draw from my conversation with Natasha Dartig, Maryland's public defender and soon to be the president of the State Bar Association? It is mind-blowing to me that if I were falsely accused of a crime and I was determined not to be poor, and that standard is really low, I would have to pay for my own pretrial supervision should I get bail. And if thereafter the charges were dismissed or I was acquitted, I would have no way to recover the money I was so compelled to spend. The state could ruin my life by bringing false charges. I'm not saying that this is rampant, but clearly the high rates of Black incarceration in Maryland and in other states means once entangled in the criminal justice system, there really isn't a way out. In the Black community, it does happen a lot, and the police has been accused of false charges a lot. That is the essence of driving while Black. A trumped-up charge brought to bring ruin, not justice. You could say suspects charged with crimes pay for lawyers, they pay for bail, so why not pretrial monitoring? And if you are really poor, there is Natasha Dartig's roster of public defenders. Everyone else, pay for your own defense and liberty. There is also the final possibility that some judges might find the police and prosecutors in the wrong and make some recompense, but that is rare. In the case of long periods of false incarceration, many states have paid damages, but that too is rare. These arguments are joined with a fairly widespread belief in society that if the police arrest you, you must have done something. And sometimes that something cannot be proven in a court of law because of evidence rules, witness tampering, poor preparation by prosecutors, whatever. So punish them now without the trial. But you have to ask yourself what a system we have created where we not only take away the liberty of a suspect charged, but also drown their family in new burdens, feeding the cycle of failure, collective and generational punishment. Somehow a pretrial system where we lean on suspects to take the plea deal, even when they might be innocent, by creating financial burdens for them and their families, that approximates for justice, which should only come, really, after the trial is over. We don't want to spend money protecting the rights of criminals, but we also don't give an iota of thought about what might happen if it were us. We also don't want to spend money on policing because they will never be all right. Defund the police, we say. The problem is largely constructed around race. But if you really think about it, it could be anyone. That's all for this episode of I Hate Politics, where we aim to stem the decline in local news by working with community voices. Don't forget to tune in to our Tuesday morning news analysis. I Hate Politics is produced by me, Sunil Dasgupta, with support from the University of Maryland, Baltimore County. I direct UMBC's political science program at the universities at Shady Grove in Montgomery County. where, among other things, we explore and learn about politics, government, and society close to home. Music for this episode comes from Silver Spring power pop band, the Airport 77s, Andy Sullivan on guitar, John Kelly on the drums, and Cal Everett on the bass. The songs for this episode come from their new album, Don't Let Go. You can find their music at airport77s.com and at live concerts all over the DC region. If you want to share your music on the show or know someone else who might want to, please email us at producer@ihppod.org. I hope you will subscribe and share the podcast as we bring you stories about politics close to you and to your home. See you next time.
Do you like ice cream? Depends on the time of year. Take it or leave it in February, but summer's almost here. I got a buddy down at Baskin Robbins, maybe he can hook us up. 31 flavors, rainbow jimmies, need a bucket loader, let's hop a city bus, see where it takes us. Wind up in some neighborhood where we've never been before. Maybe we can make new friends, maybe we'll just get lost. Ask our fellow strap hangers where they think we should get off. 'Cause I'm in, if it's on, I'm in. Can't